Good morning, viewers. Welcome to Consumer Shorthand classes. Get ready. 5 seconds. Start. The failure on the part of the court to stop the investigation on the expiry of 6 months as provided will not be deemed to be an implied permission by the court to the investigating officer to continue the investigation beyond the prescribed period, as the continuation of the investigation beyond the prescribed period could be permitted by the court only for special reasons and in the interest of justice. The power to remand and detain an accused in custody is only while the investigation is pending. It comes to an end as soon as the charge sheet is filed or the investigation is stopped. Viewed in this context, it appears that Section 167 is mandatory in character, and it is the duty enjoined upon the magistrate by the law to see that no investigation is continued in a summons case beyond 6 months from the date of arrest of the accused without his permission. The magistrate and the police officers have to pay proper regard to this statutory provision of law which has been enacted not only in the interest of under trials but also in the interest of society. The scheme has to be read harmoniously, namely, A. Investigation will be completed within a period of 6 months. B. If, however, there are special reasons and the interest of justice require, the magistrate may permit the continuation of investigation beyond the period of 6 months. And C. If, however, the magistrate doesn't so permit, the sessions judge may do so. Though normally one would expect the police to move the magistrate within a period of 6 months if it wishes to continue the investigation beyond that period. But in law, it does not follow that if application is moved beyond the period of 6 months, the magistrate has no jurisdiction to deal with such a request of the prosecution. Investigation concludes at a stage prior to forwarding a final report where no case has been made out or when charge sheet is filed before the magistrate. Charge sheets duly filed, investigation not completed within the period of 6 months. In all these charge sheets filed, the magistrate can look into the material which had been collected within the period of 6 months and ignore the other material gathered beyond that period and then decide whether to take cognizance or not. Investigation carried on after the expiry of the period of 6 months was without jurisdiction and cognizance taken on police report based upon such an investigation was bad in law. The subsequent proceeding was without jurisdiction. In the court of the district magistrate at Hyderabad, criminal case number 100 of 2000, between the petitioner accused Mr. Razu versus the respondent complainant Mr. Ravi. Application under section 167 Criminal Procedure Code. The accused petitioner above named begs to submit 1. That for an alleged offence, the complainant police registered a case and the accused petitioner was arrested on 1/10/2000. 2. That the case is triable as a summons case. 3. That the permissible period of 6 months has come to an end on 1/4/2001 and the investigation still continuing beyond the period of the said statutory period of 6 months without seeking any permission from the magistrate for continuation of investigation beyond such period on the ground of any special reasons. The accused petitioner prays that the Honorable Court be pleased to pass orders stopping further investigation into the alleged offences forthwith and holding the investigation carried on after the expiry of the prescribed period of 6 months without jurisdiction and illegal, and the petitioner, as in duty bound, shall ever pray. Accused petitioner, advocate for accused.